Good morning, Mr. Chairman, member of the committee, right? Member. For the record, Jamie Berger, representing District 27. Thank you for the opportunity to present Senate Bill 558. Senate Bill 558 would increase the number of circuit judges in the 32nd Judicial Circuit from 2 to 3. The 32nd Judicial Circuit includes Perry, Ballinger, and Cape Girardeau counties. In order to qualify under the statute, they need to show a need for 2 or more additional circuit judges for 3 consecutive years, and that has been accomplished. There are a large number of jury trials currently scheduled with many days, having 3 or 4 scheduled in case some settle or plead guilty. If someone wants a jury trial, it would have to be scheduled for 2026 currently. The 32nd Circuit has been without an associate circuit judge since the first of the year, and they're trying to make the best of it. I did talk with Circuit Judge Scott Lipke for a little bit yesterday through texting, and he responded. What I learned was that to qualify under the statute, we're supposed to show a need for 2 or more additional circuit judges for 3 consecutive years. We did until last year, when the workload study shows us needing an additional 1.73 circuit judges. It doesn't preclude you're asking, but still wanted to let you know what I found out. We do have a large number of jury trials scheduled with many days, having 3 or 4 scheduled in case some pled guilty. Additionally, we have been without an associate circuit judge since the first of the year. So with that, I kind of present what this bill, and I can answer any questions, but the questions may be better answered from the witnesses here, please.
Any questions? Seeing none, first witness in support, please come forward. Got a lot of witnesses here. Seeing none, any witnesses in opposition? Seeing none, and I will tell you, I spoke with some of the prosecutors in the area that are impacted and are very supportive of this. Any for informational purposes? Seeing none, any closing remarks?
Thank you for allowing me to present.
Absolutely. That will conclude the public hearing on Senate Bill 558. We're going to move to the public hearing on Senate Bill 447. Senator Trent. Proceed when ready.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. This is the juror compensation bill, Senate Bill 447. So essentially what we want to do is provide some flexibility to counties to provide more compensation to jurors. So we basically add in, like right now the statute reads $6 a day. We add in a minimum of $6 a day, so that can be adjusted upward if they would so choose. There's a mileage rate that we conform to the mileage rate of state employees. That's currently 7 cents a mile. And then for grand and petite jurors in certain counties, such as Clay and Greene, we allow for a compensation structure where basically after the 3rd day of actual service, they can increase that pay to $50 a day from its current rate. So again, you know, the jurors are typically the lowest paid folks that are in the room. Their job is very important. We have a hard time recruiting jurors in some cases, and so we want to adequately compensate. Well, it still probably won't be adequate. We want to better compensate jurors for the time that they're having to dedicate to this, and we want jurors to feel better about their participation in the process because their participation is critical. Would be happy to answer any questions the committee has.
Thank you, Senator. I know you were on the Judiciary Committee the past 2 years. This is identical to the bills that we heard and passed and actually made it out of our chamber, correct?
Yes, this is identical to Senate Bill 897 in 2024 and Senate Bill 1220 in 2024.
Perfect. Any questions?
Order provisions that were there.
Senator, just real quick, just confirming, this doesn't have a fiscal note, right? Like this is on.
Here you go.
Oh, here it is. Yeah, it's 0. That's what I thought it would be. Thank you so much. A great bill.
Great bill. Vote yes. Any witnesses here in support? Please come forward. And proceed when ready.
Mr. Chair, Mr. Vice Chair, Eric Jennings, Supreme Court Government Relations Counsel on behalf of the Judicial Conference of Missouri. Wanted to thank first Senator Trent for his continued sponsorship of this and work on it. It has moved through both chambers, made good progress, but never quite reached the finish line in the last year. If there are any questions about the particulars, I'd be glad to answer those, but this, as he mentioned, two primary components. We would at least tie the mileage rate to a dynamic measure, whatever the mileage rate is for state employees, and it would also provide at least one more option, one that's worked successfully in Greene County and Clay County for the better part of a decade, provide that option to other counties as well as we continue to work on better compensating jurors.
Any questions? Seeing none. Thank you for your testimony and bringing this bill back. It is absolutely needed. Any other witnesses in support? Seeing none. Any witnesses in opposition? Seeing none. Any informational purposes? Seeing none. Closing remarks.
Appreciate the committee's consideration and time.
Thank you, Senator. That will conclude the public hearing on Senate Bill 447. We are now going to move to Senate bills of mine, since those are the last, and we're going to start with Senate Bill 506. Mr. Vice Chair, take it away. 506. Thank you, Mr. Chairman. Members of the committee, for the record, State Senator Nick Schroer on Senate Bill 506. This is a measure that proposes to repeal the divisive continuing education requirement that went into effect in 2019 on implicit bias, diversity, inclusion, and cultural competency. This bill represents a deliberate step toward refining our approach to professional standards, aligning them with principles of fairness, merit, and individual responsibility. Codified in Rule 1505, the Missouri Bar's continuing legal education standards, this policy requires at least 1 credit hour of such training. At the time, this move mirrored a national trend across states, or across the country, adopting similar radical requirements in many states. For nearly 6 years, this mandatory provision has stood as part of Missouri's legal licensure framework. Yet, as our state's priorities and perspectives have evolved, so too has the conversation about its relevance. In 2025, we have witnessed President Trump removing many of these divisive programs throughout the federal government. Many states are even moving away from this requirement in the legal field and many other professions where it is relevant. Just this year, Governor Mike Kehoe took a stand against these divisive programs in signing Executive Order 2518, signed on February 17, 2025. To paraphrase our statewide officials, the CLE requirement is a way for attorneys to stay up to date with advancements in law, not to be lectured with indoctrination. It is literally the #1 issue that I am asked to tackle when I speak to attorneys across this great state, is the removal of this requirement. They believe it's unnecessary and duplicative. By repealing the CLE requirement, Missouri reaffirms its commitment to a legal system that values fairness and the impartial administration of justice. We reject the divisive policies that sort and separate us based on identity, and we embrace the founding principles of our nation: liberty, justice, and equal opportunity for all. And with that, I would take any questions on Senate Bill number 506.
Any questions for the bill sponsor? Seeing none. Anyone here to testify in favor of Senate Bill 506?
Good morning. This is State Treasurer Vivek Malik, Mr. Chair, and members of the committee. Thank you for the opportunity to testify in support of Senate Bill 506, legislation that upholds the integrity of Missouri's legal profession by ensuring that attorneys are not subjected to ideological mandates under the guise of continuing legal education. As Missouri State Treasurer and a licensed attorney, I understand the importance of legal ethics and professional responsibility. That is why CLE requirements exist, to ensure that attorneys remain competent and well-versed in their ethical duties. However, Rule 15.05, requirement that attorneys undergo annual training is implicit bias, diversity, inclusion, or cultural competencies, an unnecessary and inappropriate intrusion into legal education. CLE should focus on tangible legal skills that directly impact an attorney's ability to serve clients and uphold the law, not serve as a tool for ideological enforcement. Requiring attorneys to participate in training that often promotes a singular political viewpoint undermines the very principles of fairness and neutrality that our legal system is built upon. Attorneys should not be forced to engage in courses that assume bias is inherent or that mandate a specific worldview under the banner of ethics training. It is important to note that the recent amendments to Model Rule 8.4G encourage the elimination of bias and harassment by lawyers, codifying rules that are already in place in numerous states nationwide. This demonstrates that there are existing professional standards to address misconduct without the need for mandated ideological training that presumes bias or requires attorneys to subscribe to a particular perspective. Whether attorneys should take such courses should rest with the individual lawyer and not be dictated by a top-down requirement. The state should not be in the business of compelling speech or ideological conformity under the threat of professional non-compliance. By passing SB506, we restore common sense to Missouri's CLE requirements, reaffirming that attorneys are capable of selecting the ethics training most relevant to their practice without being subjected to politically motivated mandates. Missouri's lawyers deserve respect for being treated as professionals, not as subjects of ideological re-education. I urge this committee to support SB 506 and to stand against the unnecessary politicization of our legal profession. Thank you for your time, and I welcome any questions.
Thank you, Mr. Treasurer. Questions for the Treasurer? Seeing none, outstanding. Thanks so much for being here. Anyone else to testify in favor of Senate Bill 506? My apologies. Anyone else to testify in
Mr. Vice Chair,
opposition?
there will be a letter from, I received a message, we're going to receive a letter from the Attorney General on this. There was a letter that the Lieutenant Governor, Attorney General, and others sent out on this very issue, but the Attorney General is going to make it today. I guess due to the weather he can't, so we're going to distribute a letter and submit his testimony to the record.
Excellent, excellent. Anyone else to testify in opposition to Senate Bill 506? Seeing none. Anyone to testify for informational purposes? Seeing none. Senator, you recognize to close.
Let's move to the next bill.
All right. We will now hear Senate Bill 531. Senator, you may proceed.
Thank you, Mr. Chair. Again, for the record, State Senator Nick Schroer, Senate District 2, on Senate Bill 531, which is aimed at addressing the escalating crisis of fentanyl-related deaths by strengthening our legal framework against those who knowingly distribute this deadly substance. Fentanyl, a synthetic opioid, for those that don't know, is up to 100 times more potent than morphine and has a significant contributor to the opioid epidemic ravaging our nation and our state. The staggering number of Missourians that were killed by this horrendous toxin in the past several years underscores the urgency with which we must act. Senate Bill 531 proposes to modify the offense of murder in the first degree to include individuals who knowingly distribute or deliver any substance containing fentanyl resulting in death. By holding these murderers accountable for the lethal consequences of their willful actions, we aim to deter the distribution of this perilous drug and deliver justice for the victims and their families. This legislative measure is not merely punitive. It serves as a clear measure to those who exploit addiction for profit, demonstrating that Missouri will not tolerate the dissemination of substances that devastate our communities. With that, I will take any questions on Senate Bill 531.
Any questions for the Senator? Seeing none. Anyone here to testify in favor of Senate Bill 531? Seeing none. Anyone here to testify in opposition to Senate Bill 531? Seeing none. Anyone here to testify for informational purposes? Seeing none. That concludes our hearing on Senate Bill 531.
We're going to move out of the subcommittee and go into the regular committee, the Standing Committee on Judiciary and Civil and Criminal Jurisprudence. Mr. Secretary, please call the roll.
Senators Schroer,
Here.
Gregory 15, Brown 26, Coleman, May, Roberts, Schnelting.
Having a quorum, we will now go into executive session. Do I have a second? Having a second, I now have a motion and a second. All those in favor signify by saying aye. Aye. All those signify against say no. The ayes have it. We are in executive session. I now move that we bring Senate Bill 196 from Senator Moon before the committee. Do I have a second? Have a second. All those in favor signify by saying aye. Aye. All those against say no. And the ayes have it. Senate Bill 196 is now before the committee. This is the legislation by Senator Moon on the capital punishment for the heinous crime of sexual assault or pedophilia on a minor child. Is there any discussion on Senate Bill 196? Seeing none, Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May, Roberts, Schnelting.
By a vote of 4-1, you have due passed Senate Bill 196. I now move that we bring up Senate Bill 295 from Senator Brattin. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those against say no, and the ayes have it. The bill is now before the committee. I now have a substitute for Senate Bill 295. It has been distributed last week. If anybody has any questions on that, I have a copy before us. This just made a couple technical changes to the definitions. Yeah, one moment. Let me know if everybody has the Senate Committee sub that was distributed. So I now move that we adopt the Senate Committee sub for Senate Bill 295. Do I have a second? Having a second, all those signify by saying aye. Aye. All those against say no, and the ayes have it. Any discussion on the adoption of the substitute? Seeing none. I now move that we do pass Senate Committee substitute for Senate Bill 295. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those against say no. You guys have it. Any further discussion on the Senate Committee sub for Senate Bill 295? Seeing none, I now move that we do pass Senate Committee sub for Senate Bill 295. Mr. Secretary, please call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May, Roberts, Schnelting.
By vote of 4-1, you have due passed Senate Committee sub for Senate Bill 295. I now move that we bring Senate Bill 318 before the committee. This is the offenses on theft and retail theft. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those against say no, and the ayes have it. Senate Bill 318 is now before the committee. I have a substitute that I've distributed last week on Senate Bill 318. If anybody does not have that, I have a copy before me. Do I have a second to bring the Senate Committee substitute before the committee? Having a second. The Senate Committee substitute is now before the committee. Do we have any discussion on the substitute on Senate Bill 318? All right, and I renew my motion that we do pass Senate Committee. Well, hold on, we have to adopt the substitute. And I move that we adopt the substitute for Senate Bill 318. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those against say no. And the ayes have it. Any discussion on the Senate Committee Substitute, Senate Bill 318? Seeing none, I now renew my motion that we do pass Senate Committee Sub for Senate Bill 318. Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Coleman, May, Roberts, Schnelting.
By a vote of 4 to 1, you have do pass Senate Committee Substitute for Senate Bill 318. Seeing no further business before the committee, I now move that we exit executive session and adjourn. Do I have a second? Having a second, all those signify by saying aye. Aye. All those against say no. And the ayes have it. We are adjourned. Yep.